Our second case is Robert A. Allen versus the State of Texas from El Paso County. Mr. Allen, were the timing lights explained to you on your time limits?
I know I have 20 minutes and then 10 minutes.
Right. And then you'll have the counter there will tell you how many minutes you have left, and the light will change to yellow or orange when your 5 minutes is to go. Please proceed at your convenience.
May it please the court, counsel. This case is originating from my conviction in 1979 for the offense of aggravated kidnapping. In 2002, I filed a motion for DNA testing. It was not docketed by the court, so I came back and refiled that motion again. In May of 2005, I was bench warranted back to El Paso, where I sat in the county jail for 7 months. In January the 6th, the 13th of 2006, February the 3rd, February the 10th, and February the 23rd, I had 5 DNA hearings. At the first 4 hearings were just the state saying that they were still trying to find the evidence. The final hearing on the 23rd was the state called 4 witnesses. The main witness was Mr. Martinez, who was the custodian of evidence for the district clerk's office. His argument was that after searching the files, that the records showed that at the end of my trial, the evidence was never transferred from the court to the clerk or to anyone for storage. So the question was, at the end of my trial, where did the evidence go? And to this day, nobody can tell me. They did produce an affidavit by Sergeant Eddie Smith of the police department, just basically stated that all evidence, including all biological evidence, had been destroyed. My question was, on the affidavit, was that it was insufficient because the affidavit did not state who authorized the destruction of the evidence. The affidavit did not state when the evidence was destroyed, because the question was, what preservation of evidence statute do I fall under? In the state of Texas right now, there have been 4 preservation of evidence statutes. The first one was Article 1899A, the Texas Revised Civil Statutes, which took effect in 1971. Then you have the Code of Criminal Procedures on the duties of the district clerk. Article 2.21, Section G states that in a city of 1.7 million people or less, that the evidence cannot be destroyed until the last attorney of record and the state is informed that the evidence is to be destroyed, and the defendant must be given 31 days to respond as to whether the evidence should be destroyed or not. In this case, that was not done. The new preservation of evidence statutes that came into effect in 2001 when Senate Bill 3 brought the DNA testing in effect, Article 3839, and then was later put in 3835, clearly states that in a non-capital case, that the evidence must be preserved until the defendant either dies, makes parole, or is released to mandatory supervision. In this case, for the information of the court, I did 29 years and 10 months on a life sentence. In 2008, I was returned back to El Paso again because I filed my notice of appeal, and they had a hearing on the designation. And when the appellate record was filed, there was 5 extensions in this case, which I was not informed of any of the extensions, period, which I finally did get the last 3 extensions. When I wrote this court, they sent me the last 3, and they did not send me the first 2, but it was okay. But the main issue in this case, just to get straight to the point, is the state is arguing that the defendant cannot raise a due process issue on this appeal. The Article 65, I could call to the court's attention, Article 65.5 deals with the appeal. And I believe that the intent of the legislature was that an appeal from DNA testing is the same as in natural criminal cases, because it clearly states that an appeal under this article is to a court of appeals in the same manner as an appeal of any other criminal matter except capital murder cases, which go straight to the Texas Court of Criminal Appeals. So my argument is that For the state to say that I cannot raise a due process issue means, is the state saying that a defendant does not have the right to procedural due process in this matter? Because that is what we're actually arguing, procedural due process. What procedure is due? They're saying I don't have the right to raise a due process issue. So if I'm denied DNA testing for whatever reason, then that's basically saying that I don't have the right to appeal that denial. They also made the argument that I did not challenge the court's finding of facts. But in this case, there was no finding of facts made. The court's order just simply stated that the defendant's motion for DNA testing is denied. There were no finding of facts and conclusion of law made. Likewise, the state was required under the same statute, Article 65, that when they could not bring the evidence, they must put in writing why they could not do that. This was not done in this case. The state did file an initial response saying that they reserved their right to supplement their original answer to my DNA, but they never did state in writing why they could not produce the evidence. The only thing that was produced was the affidavit of Sergeant Eddie Smith, just basically saying that all evidence, including all biological evidence, has been destroyed. But the conflict comes because Mike Martinez says at the end of my trial, the evidence was never transferred over to anyone. Now, the DPS, they said that they did have the evidence, but at my trial, it was turned over to Mr. Wilson, who was an investigator for the district attorney's office. After my trial, again, Your Honor, there's no record of where the evidence went. It was never transferred over to anybody. So the whole question is, where did the evidence go? I asked for an order of forfeiture and destruction. The state could not produce one. They could not produce anything telling me where this evidence went. They did, however, produce 4 stock record cards stating that in the archives that on December the 30th, 1999, 4 boxes of evidence were destroyed. The state was trying to say that the physical evidence was in those boxes, but Ms. Faulkner, she clearly stated that those boxes did not contain any physical evidence. It was all paperwork, photographs, and things of this nature. So in the last 30 years, Your Honor, in fighting this case, the state cannot tell me what happened to that evidence. I'm a firm believer that the evidence has not been destroyed, and the reason why I say that is, as I pointed out in my brief, in 2006, I was told that my trial records had been shredded because they met the 5-year record retention rate, that everything was destroyed in 1984. When I came back again in 2008, I requested in my designation motion that a copy of the statement of facts from my original trial be made part of the appellate record because it was necessary to this appeal's resolution. I was told again on March the 25th, 2008, I was reminded that when I was here in 2006, I was told by the trial court and the DA who agreed, well, Mr. Allen, we told you 2 years ago when you was here that your trial records were destroyed. But they never proved whether my record was on microfilm. Contacted the 8th Court of Appeals to see if they was here in the archives. They didn't have them. But the funny thing about it is when the appellate record was filed in this case, they included a copy of the trial records of my original trial in 1979, which prompted me to file an objection to the appellate record because I was challenging the authenticity of those documents when you've told me twice that everything was destroyed. So my question was, if you said these documents were destroyed, where did you get these documents from? I have the letters where I wrote the district clerk asking, was my records on microfilm? I never received a response. I wrote several letters. They refused to answer. I went to the trial court judge. They refused to respond, which prompted me in April of 2007 to file a mandamus proceeding in this court, which the previous Justice Ann McClure did author the opinion, and my writ of mandamus against the trial court judge was conditionally granted. But in this case, the only thing they did was the order was just entered saying that defendant's motion for DNA testing is denied. As again, there was no finding of facts, no conclusion of law. So the state is saying that I did not challenge the trial court's finding. Well, how could I challenge a finding that was never made? It is not my responsibility to make the finding. I filed the motion for DNA testing. It was presented. The state could not produce the evidence. They did not reduce in writing why they could not produce the evidence. And it's just been, oh, well, we don't have it. We don't have it. Since there's no evidence, then we can't grant you a DNA testing. Maybe you can find some closure. But I think the question needs to be answered, and they haven't proved it. Where did the evidence go? And prior to the filing of this appeal, There was some more evidence was discovered in this case because all the fingerprint reports and all that was withheld from me for 30 years. And all the fingerprint reports that they produced clearly show that all the fingerprints that they got off the car that they said I wrote in, the fingerprints off the victim's purse did not match my prints. I have the reports. I have them all. But this information was not provided to me until January the 21st, 2009. I went to trial in December 1979. So the whole issue is, can the defendant raise a due process issue on appeal? I'm a firm believer that based on the statute that the legislature enacted saying that appeal in this case is in the same manner as any other appeal, if I can raise a due process issue on direct appeal as far as ineffective assistance of counsel, denial of compulsory process, these issues are raised under the Sixth Amendment as well as the 14th Amendment because this is what makes all the other amendments apply to the state. So why is it any difference in this kind of appeal? I don't think it should be. And I don't think it was the intent of the legislature for it to be when they specifically put it in Article 64.05. They clearly stated unequivocally that an appeal in this case is in the same manner as an appeal in any other case. So how the state can say I don't have a due process right is really beyond me, because that's just like saying I don't have a right to anything. So why should due process not apply in this appeal, but it applies in all other appeals, when the statute clearly states that the appeals are taken in the same manner? And that is just my point. That is the whole issue. They're saying I cannot raise a due process issue. The actual points that I raised under Pena, which came from the Waco Court of Appeals, they clearly stated that when exculpatory evidence is lost or destroyed, the state's case must be dismissed. They didn't challenge that in their brief. Their whole argument is that I could not raise a due process issue on appeal. So I believe since they didn't put up an argument to that issue under the rules of English common law, I believe that this court should take my allegations as being true and correct. You know? And that's what all I have to say for right now. If there's no questions for the court.
Not right now. Not right now. Thank you, Mr. Allen.
May it please the Court. When the Court looks at the record in this particular case, and I'm sure looks at the issues that have been raised by the briefs for the various parties, the one thing that sticks out is that ultimately this case is an appeal from a denial by a trial court of a motion for DNA testing, plain and simple. The question before this Court is, did the trial court abuse its discretion when it denied the defendant's request for DNA testing? That's the sole issue before this Court, the sole issue that's allowable under Chapter 64 of the Code of Criminal Procedure. The State would urge that there was no abuse of discretion in this particular case. The record shows that in response to his motion for DNA testing, the State held a hearing in which the appellant appeared, was represented by counsel. There was live witnesses presented. Mr. Mike Martinez, the the district clerk custodian for records, came in and testified that he had made a diligent search for the evidence in this particular case. It did not exist. Bonnie Prieto, the administrator for records management for the El Paso County, came in, testified after diligent search that no records could be found in this particular case, and that the best that she could find was that about 4 boxes of evidence pertaining to his case were destroyed in 1999. Mr. Eddie Smith, the custodian of records, evidence custodian for the El Paso Police Department, submitted an affidavit that after diligent search, they could not find any evidence that pertained to the appellant's case. What happened to the evidence, we don't know, but that doesn't do away with the fact that the trial court, after hearing all this evidence, made a finding that there was no record that the evidence existed in this particular case, and as the court can note from Chapter 64, Article 64.03 says that before a trial court can order DNA testing, it must find and can only find that the evidence must exist and it must be in a condition that it allows it to be subject to testing. In this particular case, there was no evidence whatsoever presented to the court that the evidence existed, and therefore the court was well within its discretion to rule that it could not order DNA testing in this particular case, and that's the sole issue that was before this court. The state would direct the court's attention to the case in Shannon v. State. It was a Court of Criminal Appeals case. The appellant in that particular case was convicted of capital murder. During the state's presentation of its evidence, it presented evidence of an aggravated sexual assault, which included some DNA testing. Years later, the appellant filed a request for DNA testing, and the state presented evidence from the evidence custodian that, to the best of their diligence, they could not find the DNA evidence that was previously used in the trial. The Court of Criminal Appeals found that that affidavit alone was sufficient to justify a finding by the trial court that there was no evidence available for testing, and supported a finding of no abuse of discretion by the trial court. We find that in this particular case, the situation is very analogous to the case in Shannon. The trial court fully found that there was no evidence available, and therefore did not abuse its discretion. For that reason, we feel that the appellant's petition or request for DNA testing and his appeal should be denied on that basis, that the trial court did not abuse its discretion. We also would assert, and we've raised in our brief, that the appellant has not preserved this issue for appeal. As this court is well aware, rules for preservation of appellate issues are set forth in Rule of Appellate Procedure 33.1, which essentially requires that a defendant, in order to preserve an appellate issue, make an objection in the trial court to some rule of admission or exclusion of evidence, state the reasons for why he thinks the evidence should be admitted or denied, and obtain a final ruling from the trial court. That was never done in this particular case. None of the issues, the three issues that are specified in the appellate's brief, were presented to the trial court. The trial court was not afforded the opportunity to rule on any of these issues, and therefore nothing is preserved for appeal by this particular court. Appellant's issue should be, again, denied for this particular basis. But even if the court should find that the appellant's issue is, in fact, preserved, this court has essentially no jurisdiction to consider the constitutional issues asserted by the defense. In one thing I would point out in this particular case, one thing that was omitted by the appellant when he made his argument that appeals in this particular case are in the same manner as any other criminal case, he neglected to read the first part of that chapter in Article 64.05, which states, an appeal under this chapter is to a court of appeals. The legislative intent when they enacted Chapter 64, and particularly 64.05, established a procedure whereby the legislature granted jurisdiction to district courts to handle appeals in cases involving requests for DNA evidence. But again, they did not establish a procedure whereby an appellant could openly, collaterally attack his previous conviction. The court set up a procedure that, and this is a number of cases that I've set forth in the state's brief, that the appeal has to relate to a provision or an article of Chapter 64 of the DNA testing. None of the arguments or none of the issues raised by the appellant arise under Chapter 64. His Fifth Amendment due process issue does not arise under a right or a procedure granted under Article 64 of the Code of Criminal Procedure. And therefore, as we've noted in various cases stated in the state's brief, particularly the Wolf case, the Court of Criminal Appeals case, the court basically said that appeals, the court only has the authority to issue or order DNA testing and for no other purpose. It does not have jurisdiction to consider constitutional issues collaterally attacking his original conviction. We feel that the appellant's issue should be denied on this basis also on the grounds that this court does not have jurisdiction to consider issues that collaterally attack his original conviction. And even if this court were to find that it had preserved this issue that the court abused its discretion in not holding a hearing, that the court has the jurisdiction to consider constitutional collateral attacks, none of which we feel that the state authorizes. His issues lack merit in any event. His issue number one, dealing with paragraph 34.6F, where he alleges that, well, because this evidence has been lost or misplaced, that he's entitled to a new trial, lacks merit because under 34.6F, it only refers to documents that are necessary for an appeal, and if those documents are lost, that a person may be entitled to a new trial. In this particular case, his appeal is from the denial of the trial court's request for his DNA testing. This lost evidence, the biological evidence, has nothing whatsoever to do with his ability to prosecute his appeal from the trial court's order. His second issue about the destruction prevents briefing, again, the issues that he talks about he's being prevented from briefing relate to issues in his own original conviction and do not deal with the issues of his ability to preserve or argue that he should be granted DNA testing. And lastly, he argues that the destruction deprived him of a fair trial and denied due process. As the court is well aware, with dealing with the destruction of evidence that is possibly exculpatory, there is no denial of due process unless the appellant can show bad faith on the part of the state in the handling of the evidence, and that's established by Arizona v. Youngblood, Supreme Court case of longstanding. In this particular case, the appellant has not asserted or even alleged that there's any bad faith on the part of the state in the loss or destruction of this particular evidence, and therefore that issue has no merit either. For the various reasons, as we stated before, this case is solely an issue of whether the trial court abused its discretion in denying a request for DNA testing. The court should limit its decision to that particular basis and affirm the trial court's decision below. There's no further questions. Thank you, Your Honors.
Thank you, counsel.
If I may, I would just like to make one final issue. The two basic exhibits in this case were State's Exhibit number 20. In that exhibit was the blood, hair, skin, and fingernail scrapings that Dr. Robert Dennishay collected on the night in question. State's Exhibit number 21 was the vaginal slides that he made. On the night in question, Dr. Shea said he made approximately 4 slides, which he took 2 immediately to the lab and examined them and said he found no trace of spermatozoa whatsoever. He made that same testimony at trial. But the conflict was created because Roy Murphy, the DPS chemist, said that he examined 2 of the slides 45 days later, and he did find microscopic traces of sperm on the slides. So the conflict was created by the state because both of those were state witnesses. So are we just to say that Roy Murphy's testimony is correct and at the exclusion of Dr. Robert Dennishay, who testified that he was an emergency room trauma doctor for 15 years? The medical report in this case clearly states that his observation of the complaining witness when she came in the hospital, that her condition was calm yet crying. This does not sound like a sexual assault victim to me. Likewise, there was, when she said that she was released approximately 5 miles from Alamogordo, New Mexico, that she stopped a car with 3 men from Kentucky in it. The passenger got in the back seat. She got in the front seat, told him she had just been sexually assaulted. In the police report, she claims and stated that the driver asked her, "Do you want us to take you over there to the police in an ambulance?" Because she said she saw in the street a body, like someone was dead or they had an accident. So the driver asked her, "Do you want us to take you to the police, to the ambulance over there?" She told these 3 men, "No, I want to go back to El Paso." She said they made a U-turn, drove her back to El Paso. She went to the corner of Piedras and Copia where she called her boyfriend. She stayed approximately 1 hour with these 3 men from Kentucky. When her boyfriend showed up, he took her to Eastwood Hospital. Her trial testimony was that they would not accept her at Eastwood Hospital. That's why she went to Sierra Medical Center. but the police report clearly states that a squad car was dispatched to Eastwood Hospital where she originally went. But the police report says that when they arrived, she had left. Why did she leave? She was sexually assaulted. She left. She left Eastwood Hospital and went to Sierra Medical Center. Her boyfriend took her. But all the trial testimony was that she came in there by herself. The state never called her boyfriend to testify. The state never called her brother, because her brother was at home sleeping when this supposedly friend was staying from out of town in Colorado, was staying with them, and asked her brother, come get me. There were so many phantom witnesses in this case, the state never called any of them. But the conflict was created by the state. They called Dr. Robert Denishay. They called the DPS chemist. That's where the conflict was created at. So we just to say that the conflict was created, it's okay. Let's just sweep this under the rug. You know, I did 30 years, you know, but it was just too many holes in the case. The state, there is no statistical evidence that connects the defendant to this offense. Like I said, the purse that they had, they lifted 3 fingerprints off of it. It did not match mine. The 6 latent prints that they lifted off the car did not match mine. There was 2 partial palm prints they lifted off the trunk of the car. Nothing that they got off that car linked me to this offense. There is no physical evidence whatsoever that links me to this crime. None. None whatsoever. Just the trial testimony. But those were crucial exhibits. State's Exhibit 20, the blood, hair, fingernail scrapings, skin samples that Dr. Robert Denishay took, and State's Exhibit 21, which was the vaginal swabs. These exhibits would prove beyond a reasonable doubt that I was not the donor of anything that they found. But the state would have it that I'm just supposed to say, okay, I did 30 years in prison. Go on with your life. And I don't think that that's fair. I do not think that's fair. To say that I did not challenge the trial court's ruling on February the 10th, I did inform the trial court that I did want to make sure that I did preserve my right to appeal the destruction of the evidence. I was told by the trial court that that had nothing to do with him, that that was an appellate issue. I said, well, I just want to make sure I'm just preserving my right to appeal the destruction of this evidence. So I did make it known to the trial court. But how can I challenge a finding that was never made? There was no finding of fact and conclusion law made. The trial court's order just simply states that the defendant's motion for DNA testing is denied. There was no written explanation by the state why they could not produce the evidence. So how can I make a finding? How can I challenge something that the state itself has not produced? I can't challenge that. So it should not rest on me as a criminal defendant to challenge something that the state failed to do. The statute is specifically set up for procedure. And there was no procedure followed in this case whatsoever. None of the preservation of evidence statutes, nothing. But they're just telling me I'm just supposed to just accept the fact that we can't find everything. Everything's gone. Just go on about your life. Go on about your business. But it's affecting me for my life. Because with this criminal conviction, I will essentially be on parole for life for a crime that I did not commit. And the state cannot produce any evidence. DNA is undisputable evidence, and the state doesn't have it. They don't have it. So how do they link me to this crime? They cannot. They cannot produce one shred of physical evidence that links the defendant, Robert Anthony Allen, to this case. I'm through if the court has no further questions.
Thank you. Thank you, Mr. Allen.
You're welcome.
The case will be submitted on the brief and on your oral argument here today. And counsel, Mr. Allen, you're excused. We thank you very much. You handled yourself very well and argued quite effectively, I might say. I wish more lawyers would argue as well as you did.